Hello, friends, and welcome to this two-part lecture on the law and the judicial system. This is a fundamental aspect of American politics and American life. It's the third branch of the United States government. In fact, Alexander Hamilton, writing as Publius in Federalist 78 in defense of the ratification of the Constitution, said it would be the least dangerous branch. If you turn to Article 3 of the Constitution that details the judicial system, it is the briefest, somewhere around 350 words, not much text at all. In reality, in the 21st century in which we all live, the Supreme Court is one of the most important aspects of American political life, as well as the federal judiciary and the 50 state judiciaries. Have a tremendous impact on the lives of citizens. That's where we want to begin today. It's looking at the nature of the law itself and the types of law and the types of courts in the United States. There are different types of law, hence different types of courts. That's a truism for us to keep in mind. And I want to look at several sources of law in the American political system. In fact, we want to look at 5 to be specific. The first will be of no surprise, the U.S. Constitution, supreme law of the land. It is, as many say, and as the Constitution itself says, alludes, the highest law of the country. But the supreme law we know as the U.S. Constitution also includes the many written decisions that have been made by the Supreme Court as the highest court in the land. And so those cases, both those that are in favor of a particular plaintiff, as well as those that are not accepting of the plaintiff's claims, the minority in any kind of Supreme Court decision, those also become part of American law. And those dissenting opinions, those minority opinions, sometimes become the basis for future majority opinions. And so we see this outlined in the most general of ways in Article 3 of the Constitution. The second source of American law is statute and treaty. These are acts of Congress and treaties that have been proposed by the President and ratified by the U.S. Senate. The House is not involved in the ratification of treaties. So Congress makes laws in terms of statutes, but they also must be signed into law by the President, as we have already examined in this course. Please keep in mind that this constitutes a large amount of the laws that are made in the United States. As, after all, Congress sets the lawmaking body. The third source of law is what we call executive orders or federal regulations. These are laws that are made by the executive branch, both the 15 departments, the regulatory agencies, and the office of the president itself. The president, the modern president, contemporary president, issues many executive orders. Some of these have tremendous amount of power, but they are subordinate to acts of Congress, which is a very, very important point. Some are quasi-judicial in nature, especially when it comes from regulatory agencies, and Congress can overturn these. The fourth source of law is what we call common law and equity. This is judge-made law. These are judicial decisions. This is often referred to, as we had mentioned, as the common law. Many states have common law courts that are just based upon this way of making decisions. The United States inherited a common law tradition from Great Britain, where it had been in place for hundreds of years. The ruling of a judge in a particular case can be the precedent for a future case. Okay, we've talked about 4 sources of law. The final source, the fifth source, is what we call natural law, sometimes translated as the natural order of things, the way things should be. Arguments on the basis of natural law are in many ways the most powerful, but the most obtuse, because we have different ways of viewing natural law. Okay, those are the 5 sources of law. Let's talk about the subjects and objects of law. Legal subjects are those persons, living and corporate entities like businesses, that may initiate legal proceedings or have legal proceedings initiated against them. The legal objects are matters that are capable of judicial resolution. The people who, or person or corporation that brings a case, or even could even be the U.S. government or state governments, who bring a dispute are called the plaintiff. The dispute, the alleged source of this dispute, or the problem that needs resolution, we call the defendant. That can also be any of those entities. So that gives us some idea. We speak of plaintiff and defendant, but as the basis for any kind of judicial decision. Well, let's talk about the types of law. The probably the most common type of law in the United States is what we call civil law. The subjects of civil law are private persons for the most part. In a civil case, the plaintiff would be one individual or one group of individuals against the defendant, another individual or group of individuals. They're usually a person or persons who have suffered actual, non-trivial injury, damage, loss of rights, this sort of thing. And some types of law that would fit into the civil realm of what we call tort law, personal injury law, damage of our rights. One person can sue another. Contracts. Another very prominent type of civil law is what we call probate law. This is, to borrow the name of a television show from a few decades ago, Family Matters. Marriage, divorce, adoption, guardianship of juveniles, all those kinds of sort of family-related cases. In terms of civil law, a judgment, a ruling by a court, may involve monetary penalties, actual punitive, nominal penalties, particular orders to do something or not to do something. These judgments are not as severe as the other type of law that we're going to study. And the second type of law is what we call criminal law. The subjects of criminal law are usually someone who has committed an offense against a group of citizens or a state or potentially even a national collective of people. So typically in a criminal case, it would be the state versus the individual group of individuals who have allegedly committed this offense. It's not just thought of as an individual crime, of an individual against another individual, but an individual against a larger group of citizens, and perhaps even against the state or against the federal government. The infractions are usually more severe, or the alleged infractions. The penalties are also much more severe. They often involve fines, thoroughgoing imprisonment, and are much more severe by their nature. Usually when we think of criminal law, we think of much more serious offenses than we think in civil law. For example, murder, rape, armed robbery, assaults of various types. So this gives you some idea of what to think about the sources of law.